Edward Reyes. So, as promised, we have our panel of experts here in the room. And we are going to go live now. So, if everybody can just share it and everybody can jump on and start asking questions, and we'll introduce everybody as well. So, on the pop up, if you guys got a pop up on your phone, you got it, and then we can just share it from
Did you
there.
get it?
No, I did not
Not
get it
yet.
yet.
No.
No?
No.
You don't think I'm live? No, I'm live. I see it. Like, I'm actually watching myself live.
Yeah.
Yes, I got mine.
Oh, okay.
All right, perfect.
Hold on.
Go to your
Okay, I've got it.
notifications.
Okay, so
So, local instance 9. So this part is still still work in progress, clearly, but we are going to make this happen.
Yes, I got mine.
All right, perfect. So we are live. We are live on mine. We're live on everybody else's as well. As everybody knows, my name is Edward Reyes from the Reyes firm, and I have a group of really, really smart attorneys in the room. So I'm just happy to be here with them. And I want to introduce everybody from right to left. Liz.
hi, Liz Potts.
Where's the camera?
And
It's
Liz,
over there.
tell us a little bit about yourself briefly, and then we'll kind of go around the room a little bit.
I practice law here in Tampa, Florida, and I practice family law, some immigration, and wills, trust, and probate. I've been practicing for for 18 years.
Okay, and he's a guest of honor. He just he just came here to hang out, but he's also an attorney, and he does federal law. But he just as a guest, he's the expert. And
My name is John O'Connor. I'm a lawyer for about 30 years. I'm admitted in Puerto Rico, New York, and Florida. I'm mainly a corporate business attorney, but I litigate in the federal court, and I rely mainly on the guests that are here, or the people that are here, for good information, and more particularly Liz Potts, who I've known for many, many years.
Thank you.
That's it.
and Dax Leto, and if you want to talk about yourself and introduce yourself.
Thank you. Hi, everybody. I'm Dax Lanetto. I handle Social Security and Veterans Disability claims, both at the administrative and federal level. Basically, workers who've been injured, veterans who've been injured, I help them get their benefits from the government.
And my name is Edward Reyes. I do personal injury and real estate law here in Tampa, Florida. And if you guys are on this live, you probably know me already. But now that it's shared across the board with everybody else, hello, nice to meet you. And we're here to make some changes in our society, I think.
Hey, good evening, everyone. My name is Mike Giossi. I practice here in Tampa, Florida. I have two primary areas of practice. First is criminal defense, federal, state level, any issues with respect to that. In addition, I do first-party insurance claims on the plaintiff side. What that means is I represent insureds, so anyone that has an insurance policy, property insurance, vehicle insurance, if they have to go against their own insurance company, either if they're improperly denied or their claim was undervalued, I help them get the money that they deserve under the insurance policy.
Yeah.
Good evening, everyone. My name is attorney Deani Winter-Funde. Thanks to Eddie for organizing this much needed information that will go out. My name, again, Deani Winter-Funde. I practice only immigration law in the Tampa Bay area. I also go over and across the continental United States, and I have clients out of Europe as well. The main focus of my practice is family-based immigration. I also do removal proceedings, what that means, deportation from here all the way to Miami. I also do asylum, and I also do VAWA petitions. Throughout the course of the evening, ask any questions. We're here to answer those questions, and I'll touch base with you after this.
And Ashley, since you're here, you might as well introduce yourself.
I am Ashley Hart. I actually am a recent graduate from WMU Cooley Law School. I actually work with Eddie as the demand writer, so that's what I do currently.
That's a pretty important position, actually. You guys might not know, but it is.
So that's pretty much it for me.
So we'll wait for questions, but in case there's no questions, or if you guys are scared to ask questions, because it happens, we have some questions prepared as well that we can kind of discuss, and we can go back and forth. So I know there's some questions prepared. Ashley, you have some questions prepared, or
I have a few questions,
please
and we
ask
also.
the.
So my first question is going to be for Ms. Potts. How young is too young to have a will?
Well, it depends. Usually, when you become an adult at the age of 18, that's a time to be thinking about it. You may have items that or even a bank account. And if someone has that bank account and passes away, there's going to probably have to be some type of court action to be able to get that money out. And so if you have decided who that money should go to, you would put that in a will, or you can also do what's called a transfer on death through the bank. But it doesn't really matter how young you are, even if you were underage, if you were making a lot of money, if you were a Taylor Swift or something, chances are that you would have someone who has helped you to draw up some type of documentation or a will, because of the fact that you do have money and it needs to be, given to the next person that you would want it to go to.
Okay.
Any other question that you have?
I do
Sure.
for Miss Diani here. How has the government shutdown affected immigration?
The $1 million question. So, for the most part, what most people don't realize is that immigration is separated. We have the USCIS, United States Customs and Immigration, Citizens and Immigration Services, I stand corrected, that is totally funded by fees. So, all those fees that you pay funds USCIS. So, if you have an interview coming up, you should definitely plan on attending your interview. However, for those individuals that are in court proceedings, there are two ways that the government shutdown has affected this. For those clients that are detained, your case will still be heard. In other words, if you are in a detention center or you have some kind of monitoring device on you, your case is still going. So if you have an ICE check-in, you need to go to your ICE check-in. If you're in a detention center, your hearing is going to be on the calendar. For those non-detained clients, so you are in removal proceedings, but you're out on bond or you are walking free around, your case will not be heard. And if you have an attorney, you should be in touch with your attorney who can bring you up to speed on how that case will be rescheduled. For those that do not have an attorney, I do not recommend that you waste your time driving to Orlando or driving to wherever your court is. There's nobody there. There are no judges on the bench. What I have been told, and don't quote me on this, is that at some point when the president decides that there will no longer be a shutdown, there'll be at least a day of lead time. So you will have some way to find out whether your hearing will go or not. But my advice is make sure the court has a current address on file for you, because they will mail you those rescheduled appointments. So you want to make sure the court does have a way of getting in touch with you.
Now we do have some criminal questions that came in. We got one that says, "What are your thoughts on to blow or not to blow if you're pulled over or suspected of a DUI, and you ask to blow? What do you do?" And Mike here is the man on that subject.
Well, I will tell you this: DUIs. What most people don't realize is there's two different aspects to a DUI. There's the administrative aspect and the criminal aspect. So when you get pulled over for a DUI, if you're arrested for a DUI, you're going to lose your license, whether you blow or don't blow. The amount of time that you lose your license for will be affected by whether or not you choose to blow or not. There's a lot of different intricacies in terms of whether you have a hearing or not, but what I can tell you is if you don't blow, it is going to be a more strict period of time where you don't have a license. The second time you don't blow, it's a separate criminal offense. But on the flip side to all of that, the more evidence that the law enforcement officer has, then the harder it is to defend the criminal case. So it's difficult because some people say, hey, my driver's license is everything, and if I lose it, I can't work, I can't pick up my kids, I can't do all that. But obviously, if it's something where you believe you've had too much to drink and you blow, an otherwise defendable case may be very difficult now to defend because now you've got this high blow that you have to contend with in court. So, so that everybody understands, when you sign your driver's license, you are giving implied consent that you're going to blow. So all the penalties that stem from not blowing are the fact that you've now revoked that consent and say, hey, I don't want to blow any longer. So it really depends. From a criminal aspect, less is more. So the less you say, the less information that law enforcement has, then obviously the harder it is for the state to prove a case against you. So from that aspect alone, then obviously the do anything and just say, hey, I want an attorney present. I don't want to answer any questions without an attorney present, and go from that point. Um, but there's a lot of things that go into that decision. In other words, if you've had a DUI before, if you've refused before, now it's a separate criminal offense. So now maybe the DUI is defendable. But now it's easy for them to show, hey, you didn't blow. The penalties increase with respect to a refusal to blow. So it's a hard question to answer. I think from a purely criminal standpoint, less is more. So the less you do, the less information you give. Field sobriety exercises, providing a breath sample, that's better to defend a criminal case if you don't provide those things. And you can be very courteous and say, hey, look, I'm not gonna do anything. I don't want to do anything without an attorney present. And they're going to have to make their decision based on what they've seen so far. So the less that they've seen, then the better it is to defend. But again, it is going to mean harsher penalties for your license, which means it could be harder to then get your license back. It could be longer times where you have what's called hard time restrictions, where you can't drive at all. So it really depends on what's most important to you. But from a purely criminal standpoint, less is more.
That's good.
I
Well,
didn't know
points.
that.
Yeah, I learned a lot
I
of stuff.
did not realize
I
that.
learned every time I hang out with this guy.
Yeah.
We actually do have a question here for disability. Let me see, where's the disability one? How much does it cost to do a disability claim, and how long does it typically take? Let me zoom into docs.
Well, those are a couple great questions. Um, so I'll talk about the costs first involved in a typical disability claim. Again, I handle two types of disability, so each one's a little different. Social Security disabilities for individuals who are unable to work. And in those cases, the typical claim, most attorneys do them on a contingency fee basis. So that means if you're not awarded the benefits, then there's no charge. Now, if you are awarded the benefits, most attorneys charge 25% of the past due benefits. And why we'll get into why there's past due benefits when I address how long does it take, because that's a whole nother area. On the veterans veterans disability claims, those are also done on a contingency fee basis for the most part. Their rules allow for a little bit more flexibility in that you can charge any fee that's reasonable. The standard fee that's presumed to be reasonable and that many attorneys charge is 20% of past due benefits. There are some attorneys who charge higher percentages. They just have to show that the fee that they're charging is reasonable. So those are the two types of fees that are involved in Social Security claims and veterans claims. On one thing I forgot to mention about the Social Security claims, at some points and sometimes in the process, those fees are also capped by law. So the cap is currently $6,000. So they have several stages of appeal. So if you don't go past a certain stage, then that cap will apply, and it'll be whatever's less, either 25% or the $6,000. Now, why there's past due benefits and why the contingency fee structure is set up on that is because of how long these processes take. A typical Social Security claim, you're looking at anywhere from 18 to 24 months to get in front of a judge, and then probably another 3 to 6 months for a decision. So it's not something that you can file for today and hope to get a positive outcome right away. Now, they can be resolved faster, and a small percentage are. But I'm talking about the majority of the cases here are going to take at least 18 to 24 months most times. And during that time, if you are eventually awarded benefits, you get paid for all those months that you were owed benefits, and that's where that past due sum comes from. On the veterans claims, those vary. Um, they can take several months, but anything with the federal government, as some of our attorneys here who work in the federal government know, things move slowly, and many times they take many years. The veterans claim system doesn't have a set um, deadlines in it as far as, oh, you have to have a decision done in this many days or that. So it's really hard to say how long a claim will last. I recently, last calendar year, wrapped up a claim that I had started in 2008. So it
Oh,
took
wow.
10 years.
Well,
And that was without going to any kind of federal court. That was just in the administrative level itself. And I've had some that resolve within less than 12 months. So it just varies on the type of case and the claim that's being made.
Do all Social Security cases go before a judge, an administrative judge, or because you said it takes like 18 to 24 months to go before a judge, and then another 3 to 6 months to get a decision. So, do all of them? Do you actually stand before a judge for them to hear the case?
The grand majority, yes. I would say probably, I don't have the statistics with me, but in my practice, I would say probably 90% of them do end up going before a judge. So when I meet with a client, I often tell them they need to plan, because they're not working, how they're going to live for and survive, pay their bills for 2 years. You need to plan for the worst. If you get approved faster, some people do get approved in 3 6 months, then hey, they're fine, they'll be better off, but they need to plan for that. So and I usually tell most people at the outset, you need to go into it looking that you're going to be seeing a judge and that you're going to be going into the more extended time frame, because so few cases are won early on in the process.
um, and also before we do have a couple more questions, but also everybody will be tagged in the video. So if there's any questions you have to ask, you can ask. You can later on send them. But if you're scared to be on Facebook Live and ask your question, it's fine. You can always message them or put it in the comments, and then they'll send you a message back privately. We'll do it on ours plus the shared and on the local answers now group. So it's not like if you don't want to ask now, completely understand. We do have a question here. It's actually a question for me. Is what are the steps for a personal injury lawsuit, and how much does a personal injury lawyer cost? Well, the steps, it depends on the type of case. If it's auto accident, if it's premise liability, but the first thing is we need to have documentation. We need to have an incident report from either a police officer or from it could be either at a store. It could be the manager. They have to fill out an incident report, or we need to have some sort of record that the incident actually happened, and then we have to have injury, because hence the word personal injury. We need to have an injury. A lot of people, they call and they just have property damage, which is fine, but if there's no injury, there's no lawsuit as far as no settlement for that purpose. And then we need documentation that you went to a doctor, you went to the hospital, you went all the different places you went to, because that helps build the record. Because the insurance company doesn't know you; they only know you what's on paper. So if you don't treat, or if nothing happens, your case actually dwindles quite a bit. So that's kind of how that process goes. As far as, and then once we get all the medical records, we have Ashley. She does a lot of demands, and we have Tanya. She does the case management, and my wife Maria as well. They all work together to kind of paint the picture. It's like an artist putting together a portrait, and everybody's painting at a different stroke, but eventually it's going to be a beautiful picture at the end. And if the insurance company doesn't want to pay, and we can't get them to move, and then we'll file suit. So that's a whole other conversation once we get to that point. As far as cost, it's Florida Bar pretty much sets it. It's 33 and a third % plus any cost. If you don't file suit, and then it goes to 40. That's across the board. That's majority what every attorney contract says, but it's contingency fee, meaning that you don't pay unless we actually win. So that's kind of how that works. It's kind of a good conversation. I don't have to charge people when they get here, but they do. But I do. My income is directly related to the amount of money we get them. So it's in our best interest to get as much money as possible for our clients for their injuries, and for their families. So that's kind of a very broad view from how a personal injury case is structured and how we get paid. We also have another question too about red light camera, and let me see what it was. Red light camera ticket. I heard you don't have to pay those. What are your thoughts?
No, any ticket you get, you got to pay it, because if not, you're gonna lose your license and get bigger fines. So here's the thing with a red light camera ticket. When you get a red light camera ticket, it's not going to affect it's a non-moving violation at that point, in the sense that they don't know who the driver is, right? The red light ticket is just for the owner of the vehicle, the registered owner. So they can't say that I'm driving my car or my wife's driving my car. They just know somebody's driving my car and runs a red light. So if you pay that within the amount of time, it's a fine, but there's no points assessed, and your insurance is not going to go up, all right? If you don't pay that ticket, what ends up happening is it does then get filed in court. It now becomes a moving violation, so that you can get points assessed. So that if you do get a conviction or an adjudication, it will affect your insurance. So if you get red light camera tickets, pay them fast, and just be done with them. Because if you don't, and ultimately they file, now it does become something that can affect your driver's license. And then you have to have a hearing, then you have to appear, and then quite possibly hire an attorney, and it's just a lot more money. So with a red light camera ticket, it's better just to pay them and be done with them, and move on.
Okay. We have a question here for the immigration expert, Diani. It says, if someone's visa has expired, what should they do?
Leave the country.
Okay.
Well, ideally, I always counsel clients to make sure whatever status you come in on, whether it's non-immigrant or immigrant, and I'm assuming this is going to be the non-immigrant question, meaning you're in here as a tourist. That's the most common ones that think, what should I do? It is very important that individuals separate the visa from their travel document. The visa is what your country gives you. You might have gotten it at a consulate abroad, for example. And I'm going to use the most common type of visa, the tourist visa. And for the most part, it says you're coming to Disney World. You will not work. You will do nothing. You will visit and you will leave. That is the most common way that individuals enter the United States when we're thinking of non-immigrant status, meaning you're not here to live. You're not here to seek employment. You're not here to go to school. You come and you leave. It is very important that when you land at the border that you look at the I-94 that you're given. It is that document that says you can stay in the United States for X. The I-94 is going to have a different time frame than your visa. You might have been given a 10-year visa at your consulate abroad. That is a 10-year visa. That means for the duration of 10 years, you can enter the United States, you can visit, and then you leave. When you land at a border, whether it's Miami or a port of entry, Orlando or Atlanta, that officer is going to grant you what we call a I-94. That document is a controlling document, not the visa you were given at your consulate abroad. That I-94 will say 6 months, that's the max. Sometimes it might say 40 days or it might say 3 months. You cannot allow that I-94 to expire. And I think that is where the question is going. When that expires, what happens? If that I-94 says you have to leave by March 3rd and today's March 4th, and I'm physically looking at you in my office, you are what we call an overstay. In other words, you can be removed from the United States. It is important that 45 days before that I-94 expire, if you think you need to stay longer in the United States, you submit an extension. Otherwise, you need to make what we call an orderly departure, meaning you cannot leave, go to the Bahamas, come back real quick and get another stamp. You need to go back to your country from which you came. So if your visa expires, you have a whole different problem. You need to renew your visa. If your I-94 expires, you're now considered an overstay.
Something like that, if you have that overstay on your I-94, does that cause any issues with your visa?
Yes, yes. Once you leave, and that's why I say the orderly departure. If you have that I-94 overstay and you decide, I want to leave the United States, the moment you land into the country that issued the actual visa, they're going to cancel that visa. And it depends how many days you have. If you have 180 days or less, you're barred from re-entering the for 3 years. And if you have 180 days or more, it's a 10-year bar. So if you find yourself with an expired I-94, come talk to me before you
Okay,
leave.
all right. We do have a question on it's a criminal question actually. And Liz, I actually have some family law questions after that to ask you, but
Okay.
because I know Mike has to get out of the topic earlier.
Oh, no, you're fine.
Okay.
Don't leave us, Mike.
I
Come
know,
on,
I know.
we're just getting warmed
I know.
up.
I know. I'm sorry.
So this is a topic because it's on marijuana, and you know how everything's kind of changing now. So
Mm.
is it true that if you're caught with marijuana in Florida, you just get a ticket, no criminal offense?
No, unfortunately, that's not true. So everybody's heard about the marijuana debate, and so everybody understands there's two different things that are going on. Okay, there is the federal government and the state government. The federal government still says marijuana is illegal. They have it as one of the worst type of drugs, and right now it is illegal on all federal levels. Then you go to the states, and every state is doing something a little bit different. Okay, so you have medical marijuana here in Florida. You've got states like Colorado and California that not only allow medical marijuana but recreational marijuana. So from state to state, it's a little bit different. If with respect to the federal government, it is still illegal. It no matter if you're in California, Colorado, Florida, it is still illegal, and you can still be prosecuted. They're not doing it, and they're typically letting things like that slide unless you're a big narco trafficker.
Sure.
But in Florida, to answer the question, it will not be a ticket. So in Florida, if you have anything that is less than 20 grams, that is a misdemeanor. Okay, so if you're caught with a joint, it's going to be a misdemeanor. It still is a first degree misdemeanor. Okay, so you can still get up to a year in county jail. You can still get up to a year of probation. The really bad thing about marijuana, whether it's a misdemeanor or a felony amount, is that if you get a conviction, you will lose your license for a year. Okay, so that is something that I ultimately litigate a case over because my client's going to lose their license for a year, even if it's a felony marijuana charge and I get it reduced to a misdemeanor. So the biggest thing you have to realize is not only is it not a ticket, but you're going to lose your license for a year if you're convicted. Now, anything that is over 20 grams, okay, so once we get over that 20 gram mark, now that's a felony. So now that becomes a third degree felony. That becomes 5 years of either probation or up to prison. You get convicted of that, you're a convicted felon, a lot of other things that come with that. So what I would tell you is this, right now I know that everybody says, oh, it's not a big deal. Everybody's doing it. In Florida, if you're eligible, get a medical marijuana card, okay, and stick to that. If you're not, it is still a crime. It's either a misdemeanor or a felony. It is not just a ticket, and the consequences are such that you could lose your license for up to a year, which again, just is going to cause more issues, whether it be for work, for school, for taking your kids around. You get too many of those, that becomes a felony. If you get too many driving while license suspended, and it really is just a bad way that the system takes a hold of people when they lose their license. So unfortunately, the answer to the question, no, it is a crime.
Mike, if I may ask, now with the medical marijuana cards being issued in Florida, like my practice with Social Security and VA, we are entering federal buildings. So I have clients who say, well, I've got a medical marijuana card. Is it all right if I bring my medical marijuana with me into these buildings, which are federal buildings? Could you touch on
Sure.
on that for
No,
us?
Jackson, and to answer the question, no.
Or no?
And listen, it's the same thing. And people ask me the same thing going to an airport. They'll say, "Hey, I have a medical marijuana card, and I'm flying, and I'm going to Colorado where I can buy it there recreationally." Problem is, once you get into that federal jurisdiction, the federal law is going to hold, not state law. So if you go into an airport, if you go into a federal building, those federal officers are not going to care that you have a Florida medical marijuana card. They're going to say, hey, it's illegal under the federal system, and they can still prosecute you for it. So, no, if you're flying, if you're going to a VA hospital or you're going to a federal courthouse, leave your marijuana at home, and don't count on anything having to do with the federal government allowing you to have marijuana, because right now it is still illegal.
And just to piggyback on that, Mike, what if you get your marijuana card post arrest? Meaning you've been stopped, you charged with possession, so you run out and try to kind of mitigate your damages.
Sure.
And you get the card. How does that affect the prior arrest?
Well, I think you use a perfect word. It's mitigation. It's something that I've had cases like that where I will try to use that with the state attorney and say, hey, look, my client didn't have it at the time, but subsequent to it, he's gotten his medical marijuana card, and this would be a substance that he would have been able to get with the medical marijuana card.
Okay.
What happens more often than not is some of the stuff that you can get with the medical marijuana card is not typically what they find you with. So
THC, the
right,
oils.
right.
Yeah.
So unfortunately, it's not same.
Right.
But so it is something that I think you could use in mitigation with the state attorney.
Mhm.
It would not be a legal defense in the sense that, hey, now I have it, but I do think that it's something that you could ultimately argue in front of a jury.
Okay.
In mitigation, and you never know if you get jury nullification because of it. I think marijuana cases, especially dispossession cases, are tough for the state anyways, because so many people have the mindset now that, hey, marijuana is okay. So if somebody is caught with a misdemeanor amount, as long as they're not growing a bunch of it or bringing pounds of it in, it's not that big a deal.
Okay.
So I think it could be used to mitigate certain aspects of it. You would not be able to say, hey, I'm going to file a motion to dismiss and have a court look at it from that aspect based on that.
Okay.
Liz, so I know this question comes to me quite a bit, but now I definitely send them all to you.
Thank you.
Damn, family law. So one of the questions that that people ask all the time: does child support equal time sharing? Because a lot of people, they're like, well, this person's not paying the child support, so I'm not gonna let them see the child, or vice versa.
Don't be doing that. Child support and time sharing are separate.
Okay.
So, just because somebody isn't paying child support doesn't mean that that person cannot see their child. I just had somebody call today, and he wants 50-50 parenting time because he thinks that he won't have to pay any child support at all, because that's another myth. And what happens is when we have the 50-50 time sharing, if one of the individuals is making more money than the other, regardless of the fact that you have the children 50-50, one of you is going to be paying some amount, but it's going to be a reduced amount of money because of the fact that the two of you have the children for an equal amount of time.
And on that same subject, what would happen in the scenario when somebody works under the table? Because that does come up.
Ay, ay, ay. That's very difficult. And unless somebody's got money for either a forensic accountant or something like that, getting paid under the table is going to be a very difficult thing to prove.
Sure.
Because you're not going to see it. Usually it's in cash. You're not going to see it in a bank account or anything else. It's not going to be claimed on taxes. So, that's something that you kind of have to roll with. And in those types of cases, a lot of times you want to, maybe have the parties discuss, look, you pay for this or you pay for that, things of that nature.
Sure.
Because it's going to be difficult to deal with that cash basis.
Okay, and a lot of people too have I've seen people ask on Facebook, what happens if somebody wants to separate, they live in the same house, and they're like, I want to move, will I lose my house?
Oh, just put red tape down the middle and everything will be fine.
Yeah.
No, not necessarily. But if you have children, take the children with you. Don't be leaving them in the house. Reason being, once you leave it's going to be very difficult to get those children back. And so my recommendation would be take the children with you, and try to set up some type of time sharing with the other parent. Leaving the house, it's a marital asset,
Okay.
hopefully still, and not a liability. And that's going to be something that's going to have to be negotiated, when we come down to trying to settle the case.
Okay. And then actually another family we see now they're just coming. Now they're just coming. At what age can a child decide which parent to live with?
That's very discretionary. The courts, if they wanted to, could talk to a child, and usually that would be in camera, or that's just the judge and the child one-on-one. Sometimes the court reporter might be in there. It just depends. But the courts usually don't like to hear from the kids.
Okay.
If the kids have had input, or if they're older and more mature, I think that it says that, if the child shows maturity and things of that nature, they might be able to have some input. But that's really a decision of the parents. I've had children that are like 14 and 15, and I feel that they should have some type of input.
Sure.
Because they are older, and they just seem to, like dad's real into sports, and the son was real into soccer and stuff like that, and the father really got that. And so I think that that's another one of those issues that you're going to have to kind of discuss through settlement.
Okay.
Liz, have you had, I know for some of my clients, I'll have one undocumented and somebody's documented, and in the middle, I have U.S. citizen children. How do you counsel those? Do you say set up a plan just in case somebody is removed? How do you counsel those clients?
There's one right now. I'm actually doing an opinion letter on, and a lot of times it has to do with those certain circumstances, depending on what country they have to go back to and things like that. Because a lot of times it's the mother, and the mother doesn't want to leave the children and all of that kind of stuff. It's very, very hard, and you have to wait. You have to look at, the magic words are what's in the best interest of the child, and so you're going to have to look to see if this child goes back with this parent, say,
Right.
to Haiti, and they just had another earthquake or something. It's like, okay, is that the best thing to do for this child? Or because the child is getting ready to go into daycare and all this other kind of stuff, is it better to keep him here? How are we going to be able to work something like that? It takes a lot to make those types of decisions, and I don't see where the courts can necessarily just say, no, this is the way it's going to be. I think that has a lot of everybody coming together and bringing as much information as possible as to what would be in the best interest of the child, not what the parental units are all about, but what the child needs.
And Liz, you have another moment of spotlight here.
Yes.
So,
Another question.
do you have to file divorce in the same state that you were married?
No, because you may move, and here in the state of Florida, you become a resident after living here for 6 months. And usually, right when you move here, technically, I think within 10 days, you're supposed to have your driver's license changed to a Florida driver's license. Not everybody does that. So what we would have to do is have a corroborating witness or someone to prove that you've lived here for at least 6 months. But if you have children, it's going to be where the children live. So
Okay.
if, say, you lived in Illinois, you moved down here, you got divorced, but you stayed here with the kids, and dad moved to Georgia, dad is not going to be able to file for divorce up there because the children are here. And so Florida is going to have jurisdiction where the children are, because we're going to be talking about time sharing, we're talking about child support and things of that nature.
Okay. And do grandparents have any rights?
Oh, it's a loaded question. That really depends if they've had a significant time in the child's life, or if like a parent had died or something like that, there has to be certain criteria that is looked at in order for a grandparent to say that I want to see my grandchild. But just because you are a grandparent doesn't give you a right to be able to see your grandchild.
Okay. Okay. Do you guys have any other
I
questions? Yeah.
actually, I have a question for Liz. Since we're talking about the grandparents, not in the family law context, but in the wills context. Say my spouse and I, my wife and I, we both die. How do we direct who we have one child? How do we direct who the child then stays with? Do we get to pick, or how
Yes,
does
you
that
do.
work?
And what we usually do, it's a separate document, and that would be in a declaration of a pre-need guardian of a minor. And what you would do is, and we also do these for adults. And what this does is it helps, because if somebody became incapacitated when you did have capacity, you had made a decision who you would want to be your guardian, say your wife, and say your backup would be your brother, because maybe you have another brother who comes into the picture and says, but Dax really needs me to be his guardian. But because you had done something when you had capacity and said, no, I want my wife, and if she can't do it, then I want my other brother to do it. That's how we would work it. And if you wanted to help provide for your child, that's where you would use your will to go and set up a children's trust. But it's through a declaration of a pre-need guardian for minor that you would actually choose who you would want.
Okay.
Actually, Mr. Camarino, Brian Camarino, that he's actually couldn't make it today. He has a question.
He has a question for Mike.
A question for Mike. And I gotta make sure I give my boy props to Brian that couldn't make it today. Can a foreign national flight extradition be brought into the United States? That sounds like an immigration question.
What was the question?
Okay, say it one more time slowly.
Can a foreign national
Mm-hmm.
flight extradition be brought into the United States? You read that.
So
I don't
guess
know.
say he was.
Let's break
say
that
you have
down.
you have a foreign national.
What's that
He's
about?
coming in, say from
Oh,
Haiti
he's being
or somewhere,
extradited.
Right?
So,
That's what he's asking.
So
I think
he's
that's
coming back in here.
criminal. It depends.
Well, not even coming back. So sometimes if they can just extradite them if they think they've violated
Like
federal
Noriega
laws.
Some kind of laws.
somebody.
Mhm.
Okay.
So if they violated
El Chapo.
federal laws, they can just bring them here, even if they've never been here. So they can bring him into the country just to prosecute him.
Wow.
The
So-
answer is
Well, I mean, to answer Mr. Camarino's question, so what happens is when you have an extradition order, so there has to be enough information for the federal government to even be able to extradite someone. And so there's a couple things. You've got to look at whatever agreement, accord, or treaty that the United States has with that country to determine whether or not, hey, is there even an agreement to extradite? And they're going to look at whether or not essentially the government sets forth sufficient cause to extradite someone. And then based on that, once that happens, then they're going to move forward with the extradition. And if the host country, the home country, agrees, then they'll detain that person subject to the extradition process. Now you can waive a lot of the fight that comes along with the extradition, and it can be a lot quicker. You can fight it in your home country and say, I don't want to be extradited, and it can take a lot longer. So I think to answer Mr. Camarino's question, you can fight it. The question becomes, what is in your best interest? Do you want to sit in your home country for 2 years in custody fighting it? Do you want to try to get here on a speedier extradition and kind of get here in about 10 months, which is what it would take? And then ultimately still fight the criminal charges once you get here. And then knowing, and Yanni, you're going to know this better than I do, realizing that once that person then serves their sentence, so they're going to be deported back to their country anyway. So they get a fun ticket to come all the way here to serve prison time, and then they get sent back.
and from my experience, once the federal government has some kind of reason to come after you, they're coming after you.
Yes.
Yeah.
And for the most part, you're going to be extradited. And I agree with what you said. You might as well not fight in the home country because they're going to send you here. You might as well come.
Yeah.
Um,
And then fight. And you can
fight
still
your
fight
case
your
here.
case here.
You can still fight your case here while you're you're in custody.
Yeah.
I agree.
I actually have a question for Dax. What?
Oh no, that's no.
We concur.
Yeah.
Yes,
okay.
we do concur.
Because I'm getting, and I'm sorry if you guys see me on the phone. I'm getting text messages. I'm getting messages. I'm getting on Facebook comments. So I'm just trying to keep up with the questions. I'm a 100% disabled veteran. I took my papers to the tax collector's office last year, and they told me that I'm tax exempt for being a 100% disabled veteran. Now my mortgage company, is this a real estate question? Maybe it's a real estate question. 100% disabled. Wait, tax exempt being 100% disabled. Now they raised my mortgage because they said I was building over. This is a little bit too specific, I guess. I'm gonna have to get back to you on this, Ricky.
Let me. I
Yeah.
can address some of that.
Yeah, if you wanna
in
talk about
general
that, yeah.
terms. So if you're a veteran who's 100%
Yeah.
rated 100% permanent and total, Florida has some for you that you get because you have that rating. One of those is that you don't have to pay property taxes on your homestead, which could be a great savings, many thousands of dollars that you can save. There are actually a lot of other benefits as well. I don't know if it's still called myflorida.com or if they've changed the state's website, but if you go to Florida's website on your homestead, which could be a great savings.
See, we're live and we're live.
These things happen when you're live. Now, we're live.
I
This
think
isn't
my volume
pre-recorded.
came on. Okay.
So they have a list of everything, and if you're interested in finding out, I can provide you the list of all the benefits. I don't know them all offhand. The biggest one is the homestead, the property tax, exemption on your homestead. Now, if the mortgage company is changing your what you pay monthly because of that, that's outside of my area of expertise. So we refer that to somebody who deals with real estate.
Yeah, so I do real estate, and it depends on the taxes. More on the if there's like a contract dispute or something like that. So that would be more of a homestead question. I would have to see what percentage of disability or are you disabled, and if it's 100%, and find out what the savings are, because it depends on how disabled you are. It's how reduced your taxes will be. So it all depends on the person, and I have to just read up on it. But if that's an issue and you're trying to save money on that, I wouldn't mind reviewing, whatever they give you eligibility wise, and seeing how that could be applied with homestead. But it's probably a question we just have to call the tax collector's office and kind of work through those issues.
I have a question. Someone says, "Do you have to file taxes if you're a veteran?"
Yes.
So the answer is yes.
Well,
do.
if you're
Okay.
a veteran and you have I'm
Income.
assuming income, then yes, you have to file income taxes.
Okay.
Now, if you're a service-connected veteran and that's your only income, then no, you may not have to file taxes. There are. It depends on how much you receive. Again, this is more of a tax question, which is outside of my area of expertise. So I can give a little general knowledge, but not too much. I know it's the same thing with Social Security disability as well, because people ask me if you have, if I get Social Security, do I have to pay taxes on those benefits?
Right.
The VA benefits, if you receive VA compensation benefits, you don't have to pay taxes on that income. Now, if you have other income from other sources, you still would have to pay taxes on that. Social Security disability, the same way. If I don't know the limit off the top of my head, but there's a limit. If you only receive up to a certain amount, then it's not taxable. But if your Social Security disability is over a certain amount, and then with your other income, you're over the threshold, then it actually all becomes taxable. So it's yes and no, yes or no, I guess.
We actually have a first party question to ask you. So as you guys heard, Mike does criminal and he does first party. The question is, I had a fire and my homeowner's insurance is not being very helpful and my home is still not being fixed. They keep saying they don't need that I don't need anything. Um, and my conscience says I do need it. What do I do? Like, let's say they're not paying for like repairs or something to that effect. And we talked about
Oh
cases
no,
like that.
definitely.
Yeah.
And listen, and it's terrible. I've seen insurance companies do this, so I'm sorry. And if you need to, send me a message and we can talk more. I'll be more than happy to help you walk through it. The biggest thing with your insurance company is you have to remember the reason it's called first party is you are a party to that contract. So you get in a car accident and you come see Eddie, John Smith hits you and he has Geico. You are suing John Smith and Geico is stepping in. Okay. So you're not in privity. That means you don't have any contractual basis, no conditions, nothing that you owe to Geico. When you have your own insurance company, okay, so let's say it's Citizens, okay, and you have Citizens, you have a fire, you actually have a contract with Citizens. Your policy of insurance is your contract. So that's great for a number of different reasons because again, you have that contract with them and they have to do certain things, but that also means you have certain conditions. So when you have a claim like that, first thing is you have to follow what they say as long as it's reasonable. Okay, so if they want to come out and inspect, have you sit for what's called an examination under oath, have you provide a recorded statement, you have to do all of that because if you don't and you don't cooperate fully under the policy, then they can deny you just based on that. Okay, now if they aren't doing what they're supposed to do, all right, that's where then you would then want to contact an attorney because if they're not, then you can do different things to enforce that contract. Hopefully you don't have to file a lawsuit, but if you do that, you can do that. You can also file what's called a declaratory action. If they're saying one thing that doesn't make sense to you under the policy and your rights are uncertain, you can file a dec action in court and have a court decide what the policy actually states. But if they're not doing what they're supposed to, if first thing is you want a coverage decision, right? So you want them to say, hey, we're either going to cover you or deny you. Because if somebody comes to me and they say, hey, I'm having an issue with my insurance company, one of the first things I'm going to ask them is, what's their position? Have they told you whether they're admitting coverage or not? Now, the unfortunate part is there's a trend lately that I've seen where insurance companies aren't making decisions. They will sit back and they just won't make a decision. And so I've had to file declaratory actions just to get them to make a claims decision to say, hey, whether they're admitting or denying the claim. It's terrible because we can't really even do anything and say, hey, they've broken their contract until we know what their position is. There's Florida law that says they're supposed to do it within 90 days. It's in the policies as well, but that law doesn't have any teeth. You can't file a lawsuit just based on that law. So you can't say, hey, you broke the 90-day rule and now I'm going to file a lawsuit against you. So what ends up happening is we have to file these declaratory actions and it just takes time. I tell everyone that, kind of like what Dax was saying, it takes about 2 years for those disability claims to kind of come to fruition. The unfortunate part is if we have to get into litigation with an insurance company, it's probably going to take about that same amount of time to have a resolution, to have money in your pocket. And that's the other tough thing is sometimes people have something like a fire and it is devastating and they think, okay, I'm entitled to all this money. I went through all this anguish. I went through all this stuff. Probably not, unfortunately. What you're going to be stuck with is what's under the policy. The policy governs. It is king. So you are going to be entitled to what's under the policy. Now, if there's certain things in terms of how the insurance company treated you and why they made certain decisions and how they acted towards you, then you may be entitled to what are called extra contractual damages, or you may hear them as bad faith damages. But that's a whole separate lawsuit that comes after you would prevail on the initial claim and or the breach of contract. As long as it was beneficial, the outcome to you, you could then go after these extra contractual damages. But again, it's not necessarily a given. So a lot of things with the insurance companies, the biggest issue is abide by their conditions. But if they're not doing what they're supposed to do, then definitely contact an attorney and determine what your rights are at that point in time, because you may be in a position where you can file a lawsuit. It may be something where you can at least have the insurance company on notice that, hey, this is my position. I need to hear back from you. If not, I'm going to take this as a denial. So at least there's something to show in court to say, hey, judge, we tried to do what was right, because the court's always going to look at litigation, and they want to know that was the last step you took. It wasn't, hey, I hired an attorney and we ran down to the courthouse. They want it to be, hey, you gave the insurance company the opportunity to do the right thing. They just didn't do it. It shouldn't be that way. Your insurance companies are supposed to treat you differently than anybody else, in the sense that they're supposed to look out for you. They're supposed to look for coverage. They're supposed to have your interests when they're making those decisions. The fact of the matter is, the insurance companies are really looking out for themselves, and there are certain things that they do that they shouldn't do, and if they don't do them, then you need to talk to an attorney.
I have two follow-up questions on that. One is, and this is a case that me and you spoke about, what happens, this is kind of a sentimental question, but what happens if your dog dies in the fire? It's just, it's a touchy subject, and people treat animals like, like their
Sure.
family.
No, and listen, and I know you and I talked about this. I have 2 dogs, and I would do anything and spend any money to make sure they were okay. The unfortunate part is, and going back to what I was saying earlier, the policy governs, it is king. So unless it's some dog that you can call personal property, that you've spent thousands of dollars on, and is some champion breed and things of that nature, and it's not excluded, because that's the other thing. There's exclusions all over those policies. It's really they're not going to give you any extra money. So if you went through some heartache and headache, they're not going to do that. Now, if there was something they did that was improper in how they adjusted the claim, which means how they investigated the claim, and you can somehow show bad faith damages, maybe, but probably not.
Okay, and one other follow-up question on the insurance stuff. How can an insurance company deny a claim based on the opinion of a roofer, i.e., the roof looks like it may needs to be repaired at some point?
So, what happens with a lot of these roof claims is, you've got to realize, with an insurance policy, what was the cause of the damage. Okay, so if it's windstorm, if a tree falls, those are all acts of God. Those are all accidental. They typically should be covered. Okay, unless there's, again, some exclusion. But if you have a roof leak, which is what happens to a lot of people. Okay, well, what caused a roof leak? Was it wind uplift, and was that wind uplift covered? Was it hail damage, and was that something that's covered, or is it something that is just based on the age of the roof? Is it lack of maintenance? Is it the type of material that was used for that roof? Is it the workmanship? In other words, who put it on? Is it failing because of that? And the reason that becomes important is workmanship, the materials, that type of lack of maintenance, all that is excluded under your homeowner's policy. So you may have a roof leak, you may have water coming in, but there may not be coverage. So a lot of that is going to depend upon what is the cause of that loss. So when you talk about a roof leak and you talk about the opinion of a roofer, listen, I've seen insurance companies deny claims on the opinions of people that are not engineers, and they send somebody out to look at a roof, and they'll look and say, nope, that's caused by X amount, or X, which is excluded, so we're not going to cover. Okay, I've had them send adjusters out to houses, and they say, well, even if there's a leak that was caused by wind uplift, it's been going on for a certain amount of time, and most policies, when it comes to water leaks, have an exclusion in there that's called repeated seepage or leakage. Some of them say 14 days or more. Some of them say days, months, years. Bottom line is, if they can show an extended amount of time, it's an exclusion. So I've seen people come out, and say, oh, look, that mold it's black mold, and black mold would only grow after so many days, and so they exclude it. So they can do it just based on what a roofer says, if they buy into it. Now, if they do that and they put that in a letter, now they're kind of stuck with that. So if they improperly deny it, then they could be subject to a lawsuit for breach of contract. So with your insurance company, there's 2 things. If they improperly deny you, you could file a lawsuit against them. If they undervalue your claim, so let's say they say, hey, it's covered, we're only going to pay you $1,000. You have a contract that comes out and says, no, it's $50,000. Now you could also file a lawsuit for that undervaluation. So the fact that they only paid you $1,000 when they should have paid you $50,000, you could sue for that difference in the amount of monies that they owe you.
Now, the same person asked what if the leak was behind the wall but the roof has no damage?
So if the roof has no damage, then the difficult thing is showing what the origin is. Because if the roof has no damage, then where did it come from? And if there's no damage that we can point to that's a covered cause of loss, that's going to be difficult. Now, with policies, you either have an HO3 policy or what's called a DP policy. An HO3 policy says, hey, everything is covered unless it's excluded. Okay. Most homeowners have that unless you live in a very old house or unless it's not owner occupied. If you have a DP policy, then it's peril specific, which means if it's not listed as a covered cause of loss, it's not covered. To take it a step further, with the leak behind the wall, with that repeated seepage or leakage exclusion that I was talking about a few minutes ago, the unfortunate part is a lot of these policies on top of that have a provision in there that says, hey, whether it's hidden or not, it doesn't matter. So if you have a leak that's going on for 2 months behind your wall, it could be the covered cause of loss, it could be valid, but because you didn't see it for 2 months, they could say, hey, we're not paying for it because it's been going on for that amount of time, which is terrible.
I have a question here for Diani, and then I'm going to answer a question on personal injury as well. The question for Diani is, what's the average time for a visa to be processed? And this is brother slash sister, comma, mom and daughter, etc.
So, case processing time depends. It depends on whether you're a citizen or not, whether you're a U.S. citizen or a lawful permanent resident. So, if you're a citizen, certainly for certain visa categories, the case processing times are going to be less. For a U.S. citizen filing for a parent, husband, or child, case processing times are not that long, right? But if you are filing for a brother or sister, you're in a totally different preference category. Those times can run 10 to 12 years. But if you're filing for your parents, you're filing for a husband, a spouse, or a child, then it could be anywhere from 2 years to 3 months if they're outside the country at a consulate. For US citizens within the United States, living, for example, in Tampa, Florida, and you're petitioning for a spouse, that could be anywhere from 6 to 8 months. Because I know the Tampa field office, they have really good case processing times. So it all depends where you live. And if you live in the Miami area or in Atlanta or New York, certainly your case processing times are going to be way longer. So I guess if I knew where the person lived, I can give you a little bit more information.
What about asylum? It says, what is the legal way to apply for an asylum?
Oh, that needs an in-person consultation.
Okay.
Well, when we think about asylum claims, we're thinking about a well-founded fear of persecution. So the legal way to apply, of course, like anything else with USCIS, is by filling out the asylum petition. But it really comes down to a well-founded fear, and that fear has to be grounded in one of maybe 6 categories. We're talking race, religion, particular social group, sexual orientation. So it has grounded in one of those categories. I would not advise anybody to submit an asylum petition on their own. Those are really complicated petitions. What we've seen over the years, some people are using the notarios or their friends to complete the asylum application. I would say definitely work with counsel because you need lots of documentation. You have to show the country conditions. You have to show, make sure you have filed your petition within the statutory guidelines, which is 12 months of landing within the United States. So if you've been here 18 months and all of a sudden you decide you want to file an asylum petition, you'll have to show why that petition is being filed outside of the statutory period. So I would highly recommend, if you're thinking about filing an asylum petition, that you work with competent counsel.
And I have a follow up to that. And just to clarify, can you file for asylum outside of the U.S.?
Well, that would be called refugee. So if you're outside of the United States, you do not file for asylum. You'd be filing for refugee status. And then once you're allowed in, then there's certain forms that you'll need to fill out post arrival. But asylum, the key distinction, and people use them interchangeably, asylum means your body is on U.S. soil. Refugee status means you're at some port of entry or you're outside the U.S.
Okay. I have a couple questions that people are asking me about car accidents. One of the questions is how much is my case worth? I literally get that question.
Millions and millions.
Yeah, so I get that question almost every day. How much am I gonna get out of this? Well, I don't know. So it depends. It depends on your injury. It depends on the insurance company. It depends on the adjuster, because the adjuster holds a lot of weight initially until you file suit, and then it changes. But initially, like we've had cases that the injuries are not very great, and we've gotten phenomenal outcomes for those clients. And then we have cases that they're surgical cases, and the adjuster's like, "I'll give you 2,500 pound sand," right? So it all depends on the adjuster. There's so many different variables. Any attorney that could ever tell you your case is worth this, fire them, because they're lying to you. Because there's no way to know. I mean, every case is different. Every person is different. Where they got treatment is different. It's just the medical bills. How many bills? If they got injections, and there's so many different variables that it would be unjust to tell somebody that how much their case is worth. Is their case worth something? Yes. How much? I have no idea. So that's a question I have, that somebody asked me that. I'm telling you every day. Today they said, how much am I gonna get? 100,000, 200,000? No idea. Because the commercials, they make it sound like, oh, you're gonna get this, you're gonna get that, and like Oprah, you get a car, you get a car. No, it doesn't work that way. It depends on the injuries and and also the coverage, for that matter.
You
And
were,
if there's pre-existing, yeah.
you were talking about adjusters. When I think of an adjuster, I think of cars, and I think of an adjuster going out to, like, see how bad the damage is on your car. I don't think in terms of an adjuster handling the injuries.
Well, so there's two adjusters. There's a property adjuster, and there's an adjuster for bodily injury. So when you're involved in auto, actually there's more than that. There's a personal injury adjuster, there's a bodily injury adjuster, and then there's a property damage adjuster, and sometimes there's a liability adjuster, and there's a adjuster. So it depends. It depends on where we're at. If you're getting treated at a facility like the clinic, they'll be speaking to a PIP adjuster, because they handle the medical side and the benefits. For us, we were suing the opposing side, the at-fault party, so we're speaking to the bodily injury adjuster. If there's an issue of liability, we go to that liability adjuster, which sometimes can be the same person as the bodily injury adjuster, but not always. Some insurance companies separate it, and it goes from that person to the next person. And for property damage, they have a whole property damage adjuster. So we actually have a property damage department on our, like that we work with, that they negotiate with, well, they work with the property damage adjusters to make sure we get the car fixed. So there's all these moving parts and people and everything else. It's just finding out who we need to speak to. And some people, and then they switch adjusters on a regular basis. So and every adjuster has a certain amount of money they can. Some adjusters might have a cap of 2,500. Some can go up to 5,000. Some can go higher. So sometimes they're even capped per adjuster, per tier. Geico is a big component. Some adjusters, the lower level, not when I say lower level, nobody's lower level, but when I say that, but they might have an initial cap of 2,500 only, and then it has to go to somebody up to 5. And I've been in mediations that they literally have to make phone calls to go to the next step,
Okay.
and we'll keep pushing until they get to the next step.
Eddie,
Yeah.
I know you have some other questions, but you mentioned the value of your case. You said it depends on the coverage. And a lot of people always tell me, oh, I have full coverage. Can you explain the difference between having full coverage and then the amount of coverage you have, and why just having full coverage maybe it's not enough?
So every Spanish person, and not just say Spanish, I say it because we have a lot of Spanish clients, but every single person thinks they have full coverage. There's no actual such thing as full coverage, because you would have to buy, because there's uninsured motorists, there's bodily injury, there's collision, there's comp, there's so many different coverages that you can buy. There's the umbrella policy, there's med pay, and so when people think they have full coverage, they typically have personal injury and maybe the basic BI, which the basic BI is 10,000, and personal injury by Florida is 10,000, and they have property damage. But the majority of people that think they have full coverage literally have just PIP and property damage, not realizing that property damage doesn't cover their car, covers the other person's car. They need collision, common collision to cover their own car. So we get that a lot. And then also uninsured motorists, for example, like there's a lot of people driving around in Florida that have no coverage at all. In fact, I mean, it's a big problem. So you need to have the uninsured motorist coverage in order if somebody crashes into you, they don't have insurance, that will cover you for your pain and suffering. Other ways to get coverage too is if the person that crashed into, are they a commercial vehicle? What's the commercial policy? Do they have assets?
Is that something you or Mike, do you review that with
Yeah.
people before? Yeah, I mean, I know they call you when they've already have a dispute
Sure.
or an accident or personal injury, but is that something you guys review with people beforehand? Say, hey, I want to know if I have enough coverage. Is that
Yeah, so
services you guys provide?
Yeah, so we definitely look into it. We want to make sure that there's coverage. We look at pictures on the car, see if there's any Uber stickers or Lyft stickers because of the coverages available there. If there's a company car, what are the surroundings? Are there any contributing factors that we can go after? There's so many different things to look at because sometimes it's the answer is not just a yes. It's not black and white. There's been times that they don't have uninsured motors, for example, and we ask them for the rejection form. And if they can provide the rejection form, the insurance company, they have to afford uninsured motorists to that person. So that opens up coverage that they never thought they had because the insurance company can't prove they had it. So there's a lot of different things that we do as a checkoff to see if we can get coverage for those clients.
And Dax, to answer your question, yeah, I mean, there's some clients that will come to me and say, hey, look, I don't really understand my policy, and do you mind looking at it? I mean, that's something that I'd be more than happy to do because, unfortunately, the bad thing about insurance is it's unlike most other contracts. You and I enter a contract, you can look at it, I can look at it, we can make changes and revisions and say, I don't like this word. You buy an insurance policy. What do? You go to an agent. You say, hey, this is what I want for my house, and they say, okay, this is your premium. And then about a month and a half later, you get a policy in the mail, and that policy. Then every year you get these new endorsements that change everything in the policy, and most people don't know what they have. Most people don't look at it. Most people don't read it until they have a loss. So there are definitely, and it's much more so with some commercial clients where they'll say, hey, I want to make sure that my business is covered, or hey, if I have a water leak and it damages all of my inventory, I want to make sure I'm not going to lose my shirt.
Yeah.
So they will ask me more on the front end, but that's definitely something that I do with clients because at the end of the day, knowledge is key, and knowing, hey, this is where I'm at. This is what I can, ask for. This is the coverage because, like you, most people come in and say, oh, I had this and I should get X. Well, hold on.
Yeah, that's not true.
That's not what's in the policy. So let's look at the policy to see what it states.
Well, on that, people they think there's 100,000 BI coverage, bodily injury coverage. I'm gonna get 100,000. No,
Yeah.
it depends on your injuries and it depends on the accident, and that happens. I mean,
Oh, it does.
and then there's other people that they have their injuries are much greater, and there might be only a $10,000 policy, and then they'll tender, but we only got
Yeah,
10.
they're limited there.
They're limited there. So I mean, it's kind of a catch-22. One of the questions that I got too: do you have to go to the hospital after an accident? No, you don't have to go to the hospital after the accident. In fact, the hospital is really expensive. Now, let me not say don't go to the hospital. If it's a serious accident or a serious injury, go to the hospital. Last thing we want is have you broken bones or nothing like that. But if you can hold off to the following day, it may be wise to go to a provider that can see you that specializes in personal injury and rehabilitation because the hospital is really expensive. You'll be there for many hours. And if you're doing it for the purpose of just documenting, it's too expensive. It's a $5,000 bill to have a piece of paper. It's better to, again, if you really need it, go. But if you don't need it, I would definitely look at other places that can treat you much more affordable and give you more care and more time than just give you ibuprofen and send you on your way. So that's kind of the question on that. I know we've gone for a long time. Does anybody have any other questions for anybody for that matter?
I
Through the
have a
earpiece?
quick
Yeah.
question. For wills, does Florida recognize holographic wills?
No, they do not.
Let me know
A
those.
holographic will is one where the individual writes out the will and there's no notary and there are no witnesses. It's just saying this is what I want. No, Florida does not recognize them. There was something else that I thought about that I hear a lot, and that is, well, if I don't have a will, the state of Florida is going to take all my stuff when I die. That's not true either. You either die testate, that's with a will, or intestate, without a will. And if we die intestate, we have to look to the statutes, to the law, to make the determination how your property is going to be divided and, dispersed to the new rightful owners of that property.
I do have a question. Any other, Ashton?
So I guess to follow up on the holographic will question, you said that it has to have 2 witnesses and a notary.
Yes.
So if we were to, someone, for instance, was to write up a will and then have it notarized and witnessed by 2 witnesses, would that still stand in the court of
The
law?
way, what we do when we have a will is we have what's called a signing party. And so everybody is there. Yes, it's a good party.
Yeah.
And we have the testator, the person who's created the will. We have the 2 witnesses, and we have the notary, and everybody's there. And the last person, I do this because there was a case in one of our case law books in law school, and I'll never forget. But But anyway, the testator is going to be the first one to sign. We have the 2 witnesses signing, and then we have the notary, because I have my assistant being the notary most of the time, and she is checking to make sure that all the pages are written on and initialed and this and that, and the dates are in the proper place, and everybody is signed. And because if somebody didn't sign, especially the testator, and you end up going to court because somebody's trying to say, but they meant to sign it, it's not going to mean anything. But with the holographic will, if they are going to do something, if they're going to handwrite it, they're going to have to sign in front of their 2 witnesses and that notary. Then it won't be a holographic will.
I do have one. Anybody else had? I do have a question that came in here too, and then we'll wrap it up because I know we've been going for a while. I'm actually going to chop up this video a lot and make it smaller segments because it's over an hour, and then I'll probably put all the questions and I'll put the segment, and I'll be playing these on a regular on the Local Answers Now group as well, and I'm gonna take the audio from this and make it into a podcast. So if you guys are driving far, you want to listen to an hour or something of legal knowledge, or you can't go to sleep, that's gonna happen soon.
Turn that page.
Exactly. So the question here, because with the gun laws and everybody, all that's going on, is it true that somebody can own a gun without a license as long as you keep it at home?
So yes, I mean, unless you are a convicted felon, unless you're on probation and your probationary rules don't allow you to have a firearm in the home, you can own a firearm without having a concealed weapons permit. Okay, so it takes you a little bit longer to get that firearm when you purchase it. You can't carry it on you, but you can still have it in your car. Okay, so Florida law allows you, as long as it's not readily accessible. Okay, so what does that mean? That can mean a few different things. All right, so you can't be driving your car with your gun, at the floorboard ready to use. All right, but if you have it where it is in a glove compartment inside a case, well then again, it's not readily accessible. You'd have to open the glove compartment, open the case in order to be able to use it. A lot of things that they'll look at too is was it loaded at the time? Was it something where you could just pull it out and use it in that way, or did you actually have to load it and or put a round in the chamber? So, to answer that question, you don't need a license in order to buy a firearm. Obviously, you've got to be an adult, and you can't have any of those other restrictions on you. You can purchase it, you can keep it in your home. If you do that, make sure you're safe, okay? Because even if it's not improper for you to have it, in other words, you can have it, you don't need a license. If kids get to it or if somebody utilizes it in some way, you can still be criminally liable for it, okay? So if your 6-year-old goes in and grabs it and God forbid fires it at a neighbor, you can still be criminally liable if you didn't take steps in order to ensure the safety of that firearm. So that's one big thing. And again, if you're going to drive around with it in your car, again, be safe. Make sure that you've got those 2 steps away. And if you get pulled over, okay, let a law enforcement officer know. Keep your hands on the wheel and say, "Hey, I have a firearm in the glove compartment." Okay, and if you have a concealed weapons permit, again, follow all the laws that come along with that. There's a lot of federal property, airports that don't allow you to take it in. You can't take it into a location where the primary business is the sale of alcohol, so you can't take it into bars. It gets tricky if you go to like a sports bar and they sell a lot of alcohol and things of that nature. So be smart, and if it kind of feels dumb and stupid, don't do it.
This is a real quick question, and I know the answer, but you are the family law. Have they gotten away from alimony? Is there such thing as alimony still?
Yes, there's still alimony.
Okay.
It's just that there's the tax perks for those paying alimony aren't happening anymore, and the person who's receiving alimony, it's not considered taxable. So those are the big things. They are scrutinizing alimony disbursement more now here, especially in Florida. And you're not seeing even people who have been married. They look at marriage now. They finally gave us some time periods, like 0 to 7 years is a short-term marriage, 7 to 17 is durational, and anything over 17 is a long-term marriage. And usually when you had a long-term marriage, it was a permanent periodic alimony, hands down, that's it. That is not the case anymore. A lot of times you will see a set amount for a certain amount of time.
Okay.
So that's, but yes, there's still alimony. It's just that people are shying away, saying that, there has to be a need and the ability to pay that alimony.
Okay.
Those are the big things.
Well, does anybody have any comments on themselves? Any questions before we wrap up? No?
No, I'm good.
Well,
good.
so today is the first one. And I know on the local answers now page we had some issues, and I got to change some settings there. But on my page, I've had 29 comments and 6 shares, and everybody else is sharing. So this is going to be playing for a long time, and it's going to be playing on people's feeds for a while because it's a lot of people are sharing it. So one of the things is if you have a question, put it in the comments, and one of the attorneys will answer the question for you. Because I understand that live people may not want to answer the questions or ask the questions for that matter. But they're still here to help out. We're going to be doing this once or twice a month, and we'll actually be doing smaller breakout sessions as well, because this one is the big group, and we'll have another one in Spanish sometime this month or another. And then we're going to have smaller segment groups that we have one-on-one interviews and talk about different issues and how it relates. So if you couldn't watch this and it's too long, because it's too long, I get it. We'll have smaller segments, so feel free to comment, and if there's something you want to learn more about, we'll definitely put it together. So everybody, thank you so much for watching, and it's a great pleasure of having everybody here. The first one we do, so I mean, it's going to keep growing, and I think that the more people participate, the more attorneys and the more information we can give out to society, and I think it'll be a blessing to everybody out there. So tag along and share across the board. Okay, thank you so much.
Thank you.
Thanks.
So for all of you that joined me on live,